Good evening. I am Dr. Lisa Isaac, President of Gateway Medical Society, and it is my pleasure to welcome you to the fifth installment of our 2021 Community Symposium series. Greetings and welcome to our new participants, and welcome back to those who have joined us before. Gateway Medical Society was established in Pittsburgh in 1963 as a component of the National Medical Association, and our mission is to eradicate healthcare disparities. We do this by providing education to promote public health, raising awareness of the healthcare disparities in minority and disadvantaged communities, and collaborating with other groups who have similar missions. We have had the immense pleasure of collaborating with Alpha Kappa Alpha Sorority Incorporated, Alpha Alpha Omega Chapter previously, and we're pleased to do so again today. One of the program targets for Alpha Kappa Alpha Sorority Incorporated deals with the needs and concerns of caregivers and those who receive their care. In fact, November 19th, 2021 is designated Caregivers Impact Day, where Alpha Kappa Alpha members around the world will dedicate themselves to doing something to honor and or assist caregivers. With that in mind, today we present the first of two AAO programs leading up to and dedicated to caregivers. Caregivers Impact Day Elder Law. There are various legal entities and concerns, the knowledge of which is significant to elders and those caring for them, such as wills and trusts, powers of attorney, and healthcare powers of attorney, to name a few. Well, today's program features a knowledgeable moderator and an informative panel, which includes a dedicated law professor and several law students from Duquesne University School of Law, and I am sure they will shed light on important topics, and we will all have a great opportunity to learn this evening. So I am glad you joined us for this program. Before I continue, I must take a moment to thank our symposium partners, including the Hines Endowments, UPMC, Highmark, Gateway Health, Pittsburgh Black Nurses in Action, the Links Incorporated, my sisters at Alpha Kappa Alpha Sorority Incorporated, Alpha Alpha Omega Chapter, the Ivy Charitable Endowment Incorporated, and anyone that has helped with this symposium series. Thanks to all for making this series possible. Now I would like to introduce our moderator, Dr. Christina Wilds. Dr. Wilds is currently the Director of Health Equity and Disparities for the Equitable Health Institute at Allegheny Health Network, where her work involves research, data analysis, and project management, and includes reducing health disparities, increasing care, and reducing infant mortality in underrepresented populations. She has held various positions at Highmark Health, beginning in 1999, utilizing her skills and training in both public health and education. Previously, Dr. Wilds was the manager, community health and programs, where she had oversight of employee engagement, including volunteerism, corporate-wide United Way campaign, and Highmark Walk for a Healthy Community. In previous roles at Highmark, she has developed and evaluated community-based health education programs, directed activities of the Health Education Center, and served as the Senior Program Officer for the Highmark Foundation. She was also recognized for her efforts to improve community health. Having served on numerous boards over the years, Dr. Wilds currently serves on the boards of Healthy Start, Ebenezer Development Corporation, and Crohn's and Colitis Foundation. She is also an active member of Alpha Kappa Alpha Sorority Incorporated, Alpha Alpha Omega Chapter. A 4-time graduate of the University of Pittsburgh, Dr. Wilds has earned a Doctor of Public Health, Master of Public Health, Master of Education, and Bachelor of Science degree. She won a Delta Omega Award for her doctoral dissertation for exceptional student research, and was later inducted into the Delta Omega Honorary Public Health Society. It gives me great pleasure to turn the program over to our accomplished and esteemed moderator, Dr. Christina Wilds. Dr. Wilds, thank you for joining us today.
Thank you, Dr. Isaac, for that wonderful introduction. Much appreciated. Good evening, everyone. And again, welcome to the Alpha Kappa Alpha Sorority Incorporated Alpha Alpha Omega Chapter Caregiver Impact Panel presentation. The topic today is elder law. Elder law is an area of legal practice that specializes on issues that affect the aging population. Tonight, we will learn from our illustrious panel and our students about the purpose and the importance of elder law planning. Before I begin, I would like to remind our viewers to place any comments or suggestions in the chat. And just so you know that only the moderator and the panelists can see what is in the chat. Questions will be answered at the end of the presentation. And just reminding you that this is just a 1-hour presentation. In addition to honoring caregivers today, again, we're fortunate to have a wonderful panel of students who have given their evening to answer questions and to present their knowledge. First, I'd like to introduce Attorney Grace Orsatti. Grace Wankiri Orsatti directs the Duquesne University School of Law, Wills, and Advanced Healthcare Clinic at the Trebone Center for Clinical Legal Education. The clinic prepares wills, advanced directives, and powers of attorney for income-qualified clients in the greater Pittsburgh region. She additionally directs the pro bono and externship programs at Duquesne University School of Law. Prior to her current position, Grace worked as a law clerk for Judge Dwayne Woodruff, Judge Cheryl Allen, and Judge Cynthia Baldwin. Grace is also a proud graduate of Duquesne University School of Law. Attorney Orsatti will now introduce the Duquesne law students who will share their expertise on elder law, wills, estate planning, and power of attorney. And after the panel presentations, once again, we will answer your questions from the chat. Attorney Orsatti.
Thank you so much for that kind introduction, Dr. Wilds, and thank you for inviting us here today to speak about estate planning. I have with me 8 students from Duquesne Law School. They are participants in the Wills Clinic, and some are hoping to be estate planning attorneys in the future. And we'd like to share with you some information about the importance of estate planning. If you would just bear with me for a few minutes, I will share my screen and we will start a short presentation. Before I begin, I will introduce everybody. As I said, we have 8 students. We have Anna Hossack, who is I believe, a third-year law student, Catherine Goltz, who's also a third-year law student, Zachary Valkosi, who is a second-year law student, Michael Deere, he's in his 3rd year, Frank Weber, a third-year law student, Taylor Pollier, a second-year law student, and Melanie Lewis, she's a third-year law student at Duquesne Law School. We have prepared for this presentation and we're looking forward to sharing our information with you. So I'm going to share my screen. Okay, I hope you can see this slideshow. What I would like to begin by saying is, that estate planning really is not for any age or not for any individual person. It's for everybody. Everybody needs an estate plan. And what we do at the Duquesne University School of Law Wills Clinic is for individuals who could not otherwise afford estate planning services, we provide them for free. Our clinic is income qualified, so we are under a certain threshold, under 187% of the federal poverty guidelines. We can be reached through the law school. We are open during the school semesters, during the fall semester and spring semester, and we prepare documents, we execute documents, and we work with volunteers in the Pittsburgh legal community when we do not have the resources ourselves to serve the clients who we need to serve. We prepare wills, we prepare advanced directives, and we prepare financial powers of attorney in the clinic. As I said, we have a notary, so we're able to execute documents and have everything in place for you at the time that you leave. The students undergo extensive training prior to working on any individual case, and then they're supervised by an attorney, a licensed attorney, whether that be me or any of our volunteer estate planning attorneys from the Pittsburgh community. And we seek to, again, provide this as a service to any individual who may not otherwise be able to afford legal representation, because it is essential for everybody to have an estate plan in place. So with that, and as we have prepared, I'm going to turn it over to Michael Deere and Zachary Valkosi, who are going to talk about why estate planning is important and introduce the topic of estate planning and its importance to every individual, particularly to caregivers, for whom questions such as capacity, questions such as healthcare directives and who will make healthcare decisions for somebody who's not able to make them for themselves are particularly important. So again, I will turn this over to Michael Deere and Zachary Valkovsky, and thank you again for allowing us to join you today and speak about this topic.
Thank you, Professor. Thank you, everyone. Friday night, thank the Lord it's Friday. So with that, I will jump right into this. I got 5 minutes. So, okay, so what's an estate plan? So typically when someone says, oh yeah, this is an estate plan, the first thing you think of is a will. Well, actually it's a will, a living will, financial power of attorney, healthcare power of attorney, and even funeral instructions. And this could mean if someone wants cremated or laid out in a casket, and maybe he or she wants to be laid out in a pink turtleneck or something, this can all be written into a document that your people at your death have to honor. So it's not just a will. So all right. Next slide, please. Thank you. So your estate plan sounds complex, but it's really easy. So typically with help of a lawyer, you sit down and you will go through your finances, and you can essentially say what you own and what you want to be distributed at your death and what you don't want to be distributed. And that's the whole purpose of an estate plan. You can designate individuals to take some of your property, or you can have your financial power of attorney or your healthcare power of attorney. Maybe you want certain medical decisions made by someone who you trust, and you want he or she to make those decisions for you. Well, this is all encompassed in your estate plan. Next slide, please. Thank you. So what is your estate? Now, it's important. In law school, we're told that you don't buy a house, you buy an estate. And when you pass away, you don't give your couch away or your house away, you give your estate away. So it's anything that you own and you alone in your name. So not your sister's name, not your dog's name, in your name alone. It could be your house, your car, coin collection, stamp collection, jewelry, anything like that. So it's your estate, not your house. I think I have one more slide. Okay, so intestacy. So it sounds like a stomach condition, but it's not. The intestacy is what occurs when you do not have a will and you pass away. So basically, Zach will allude to the definitions in the next slide, but I just want to leave you with one quick thing. There was a case in Pennsylvania where someone actually wrote his or her will on the back of a bumper, and a court upheld that as being a valid will because it was in writing. So a will is a written document in Pennsylvania, and it can be anything. It could be a help from your lawyer or just yourself writing it. And I think that's all I have, and my partner Zach will take it away. Thank you very much.
Thank you so much, Michael. So as Michael had said, the big scary word called intestacy is what happens. It's when you pass without a will. So it's when you don't have this important estate plan set up in place. And it's governed by the Pennsylvania Estate and Fiduciary Code, or as we call the PEF code. And unfortunately, it doesn't go how you want it all the time. It goes how the statute says, and there's nothing you can do about it. So that's why having an estate plan in place directs all of your estate to exactly whom you want it to go to. So if you want it to go to your second cousin, it'll go to your second cousin in your will. But if you want it to go to your second cousin and you don't have a will and it passes through intestacy, it's probably not going to happen. Next slide, please. So as I was saying, why is it important to have an estate plan? Not only can you direct where the certain things go, such as my car to my brother, my guitar to my niece, things along that line. It's more than just that. So important things such as guardianships. Do you have children that are under 18? Who will be their guardian if you pass away and they're still under 18? Someone needs to be providing for them, and you need to make sure you appoint someone so a court doesn't have to appoint someone that you may not want taking care of your children, which is a huge responsibility. You know, if you're not able to make your medical decisions, who do you want to make them for you? And then lastly, if you're not able to manage your finances, who are you going to give that enormous powers that my later classmates are going to touch on? Who are you going to give those powers to? Who are you going to give access to all of your bank accounts? Everything that you own, who are you going to give access to that? Next slide, please. Now, when should you make it? Immediately, right now, tomorrow, as soon as you can. Honestly, everyone should have an estate plan. I have an estate plan. I know Michael has an estate plan. I know a lot of our classmates have estate plans already drafted up because we've learned so much about this and why it is so important. Are you ready if something were to happen today, tomorrow, in 2 years? Are you ready? Do you have a plan in place? You know, God's plan is very willing, and we don't know what it is. I don't know what's coming tomorrow yet. I think I do, but I'm not sure. I want to be as prepared as I can, and so should you. Next slide, please. Now, if you do have an estate plan in place already, how long has it been since you made it? Is it more than 5 years old? Actually, today we just updated one that will be 5 years old as of today. So they wanted to make a new one because every 5 years you should be updating it. Also, after any major life event, anything that happens, marriage, divorce, birth of a child, a new grandchild, a child goes off to college, death of a family member. These are all very important life events that require you to now update your estate plan so you're better prepared for the future. Thank you.
Oops. Thank you, Zach. We're going to move on to Melanie Lewis and Anna Hossack.
So the first document that my classmate had just mentioned was your last will and testament, which are your final wishes to be carried out after a person's death. So most people will just refer to it as a will. So when they say that, this is the document that they're referring to. So on the next slide, you'll see that the sections of the will, so there's the title and name of the testator, which is the person who's writing it, an introductory clause, and then the 4 articles, their signature, and then the witnesses, we have sign it as well, and then a self-proving affidavit. So I'll explain what each of these sections are. So on the next slide, you'll see, the importance of having a will. So it's just basically to prevent conflict when families and friends are trying to determine your wishes. So it'll all be laid out right here. So you'll see why, it's so much more complicated, like he said, with intestacy laws, that you really want to have your wishes completely laid out for people to know exactly what you want to happen to things. And so they don't go to a person that you weren't intending it to go to. And the state, as he said in the intestacy laws, would make that decision for you. It would just pass according to the law instead of according to your wishes. And also important decisions such as who will care for minor children, if there are any, or incapacitated persons. But it also saves time, money, and stress for those that you love and care about you, your family members. Next slide. So this is the first paragraph. It's just the person's name who's drafting it, that wants it drafted, and then where they live, and that they are of sound mind and want to make this. But it also revokes any wills or addendums that they have previously made, so that it will be the one true will that needs to be followed. And so it won't be confusing for people who are the executor, like trying to carry out the will. If there's multiple wills, it revokes all the previous ones. Next slide. This is where an executor is appointed. So it's very important to have someone that you trust be the executor, because they are going to be the ones carrying out all of your wishes. So somebody who's very capable and that you trust to do this, to follow your will. So this is just who you name, but then also it's very important to have an alternate just in case something would happen to that person, that they would be incapacitated or unavailable to carry that out, or just not willing at that time. So sometimes it is an age thing. So my parents have listed older people as theirs, and they just might not be of sound mind in the future when my parents finally pass. So I think that it's important to have multiple people on there just in case, to cover all your bases. So the court wouldn't be appointing somebody. It's still someone that you trust and that you want to take care of your wishes. And the distribution includes the debts and funeral expenses. So those can be paid individually by those who are inheriting from the will, or just by the estate as a whole first, before things are given as gifts within the will. Tangible personal property can be specified as well. So just special donation. My mom is leaving me a lamp. So she has in her will that I'm getting this specific lamp that she wants me to have. Or there can also be a memorandum that you add that has specific personal tangible property, because then you can change your mind and you won't have to redo the entire will. So that might be a little bit easier to be able just to write down things as you think of them, and it won't have to be all at once when you go to your lawyer to draft a will. And then if you change your mind, it's not a big deal. It's not going to cost anything extra to change all that stuff instead of going to the will or going and like redoing a whole will. But also the remainder, the distribution of the entire residues, whatever's left over that isn't given specifically to people, can also be distributed. So that can include interest in a home, bank accounts, life insurance policies. But if there's no beneficiary listed, it all goes into the estate. So that would just be whatever's left over that's not specifically given to someone, and that can be distributed individually just to one person, or percentage to each person. So to children, typically, maybe if there's 2 children, 50-50, but it also can be to a corporation, like a nonprofit or something like that. But then also in the event that there's a minor child involved, you want to make sure that there's somebody that you trust to take care of those minor children. So in the event that of your passing, that somebody is going to be able to take care of these children, and it is just a nomination to the court. The court is not obligated to follow this, because they have a hearing to deem if that person is actually capable to take care of them. They take things in account like finances and other things like that, just to see if they're actually capable to take care of a child. I think that's, can you flip to the next slide, please? And to the next slide. So there's optional memorandum that I mentioned before, that there's 2. So one can be in funeral and burial wishes. So that your executor can carry those out, whether you want to be cremated or buried. If you want a specific preacher, you want to have a specific cemetery, things like that, whether you want specific songs played at the funeral, or if you don't want a funeral at all, or what you want to be buried in, those kind of things can be denoted there. And then the memorandum, as I mentioned earlier, is just how to distribute tangible personal property.
All right, so I'm going to go over some of the less known provisions that we put into a trust that are mostly preventative and are things that are really a benefit of working with an attorney, because they're taught to think of all these preventative measures to make sure that you are protecting and taking care of those people that you are leaving the money to. So a lot of these provisions involve beneficiaries that you wouldn't traditionally want to hold a substantial amount of assets in their own name. And these can be traditionally minors. You don't want to give a house to a 12-year-old or a large sum of money to a 10-year-old. So that money can be held through the Uniform Transfers to Minors Act in a deposit account, where you can name a guardian in your will, that it would enable that person to use that money or property for the benefit of the child over their life until they turn 21 or 25, depending on the state. And that way that money can still be used for their education or health or other expenses, but that way the money is protected. And once they reach that majority age of 21 or 25, then they receive the rest of the funds in that deposit account. Another really important provision that protects incapacitated or disabled beneficiaries. So having a provision in the will that sets up the ability for the executor to set up a special needs trust is really important. We like to think that nothing bad will ever happen to the people that we love, but a disability or becoming incapacitated is something that can happen at any time and at any moment. And being prepared for that and having a method for this money to be moved into a trust. That way the money doesn't take them off of any kind of federal or state government aid, any nonprofit aid that they're getting because of that disability or because they're incapacitated. Federal government aid, such as like Medicare and Medicaid, usually have to be within a certain threshold in order to get that funding or that help, and same with a lot of disability programs. So receiving some money, even if it's not a substantial amount of money or assets, could take them off of their Medicare and Medicaid and cause them to have to incur those expensive medical procedures or whatnot onto themselves. So having this money moved into a special needs trust, the executor then acts as a trustee and is able to use that money to supplement any care that they need or supplement their lives in any way that can benefit them or that the trustee finds reasonable. They can be used for a wide variety of things, such as I said, supplementing their medical care, even like recreation, or sometimes even a house or a portion of rent for their living expenses. So this way you're still able to really protect those people, such as the minors and the incapacitated or disabled beneficiary, by having that money still in a place where they're able to use it to really impact their lives in a positive way, but not giving them all that money in a way where it wouldn't help them have it in the future. Additionally, the determination of incapacity or disability is usually done through, is usually whenever the beneficiary cannot manage the beneficiary's own affairs and property, or is receiving benefits as a result of their incapacity or disability from any local, state, or federal government. And this can be determined by the executor upon consultation with their physician or another medical advisor that can say that that's deems appropriate and is necessary in the person's situation. And then I want to get on to some of the miscellaneous provisions in the will. These are mostly just important preventative provisions that are just go into the construction of the will. And the construction clause basically just says that if just one portion of the will, one sub provision is found to be oh, sorry, that's severability. Sorry. The construction clause just says that anytime there's a singular or a pronoun or a he or she, those can be interchangeable. That way there isn't an issue over just a small typo in the will and it acting out. And the bond and surety excuse is because typically a surety bond is placed so that an executor is showing that they will fulfill their legal obligations. And in this case, we just excuse that for them. And severability is what I was trying to explain earlier, where in case a sub portion of the will is deemed inoperative or illegal later on, that way the rest of the will still stand. And then can I go to the next slide, please? And then, of course, we have the testator's signature. We have a signature of 2 witnesses in Pennsylvania, and then the self-proving affidavit. And then once you have that, you have a complete last will and testament. And as my partner Melanie stressed, it's really crucial that people have this in preparation. They really are to take care and support the people that you love after you pass. And taking the time to do this now will really help save your family so much stress and anxiety during such a hard time of grief and loss.
Thank you, Anna. I believe we're going to move on to financial powers of attorney with Olivia and Taylor.
Thanks, Professor. It's just me. Olivia wasn't able to make it tonight, but I'll be talking about financial powers of attorney. And I want to talk about how they fit into a whole estate plan. So obviously, when a person dies, their will comes into effect. But before that, if a person is incapacitated, there's no way to access their financials to take care of their property during life, unless they have a financial power of attorney. I think that for a lot of people, financial powers of attorney are something that sounds scary, but as estate planners, we recommend them to everybody. And the reason for that is that without one, if you become incapacitated, there's really no way then to give somebody the authority to act on your behalf. And so you're sort of between a rock and a hard place. Next slide, please. Next slide. So what is a financial power of attorney? It's a legally binding document that authorizes a third party to manage your property and financial matters for you. It's customizable based on what you need and what you desire and what you're comfortable as the person giving that power. And anyone over the age of 18 can have one. She had included a disclaimer, but that's okay. We'll skip to the next slide. So financial POA, as we call them, power of attorney, allows decisions to be made while the principal is still alive. The principal is the person who gives the power to somebody else. And they give that power to the person who we call an agent. And so a big advantage of the financial power of attorney is that it avoids conservatorships. A lot of people are probably familiar with conservatorships now more than before because of Britney Spears. But that's a court-appointed agency principal situation. And those are very expensive because the court has to be involved in them. And we all know that going to court is very expensive, no matter what. When do you need a POA? Well, the thing is, if you're already incapacitated, it's too late to have a power of attorney. So ideally, you have one now. You have one when you set up your estate plan as part of that whole entire estate plan. Next slide, please. Go on. So how does a POA work? As I mentioned, there's a principal, and that's the person granting the power of attorney, and the agent who's entrusted with the power of attorney. They're sometimes called the attorney in fact. And it's important to notice that the agent generally cannot delegate that agency to anybody else. Go ahead to the next slide. So the power of attorney does grant broad powers. For example, the powers to sell property, to use your bank accounts and safety deposit boxes, to borrow money, to receive government benefits, and to act on you as in a legal capacity as well, to pursue claims and litigation in court. However, it's important to note that it does not give the agent the power to make medical decisions for you. Next slide. So the time of effect is that it usually, the ones that we draft largely, and we generally recommend that they take effect immediately. But in that, we also include language that when the principal gives the agent this power of attorney, that the agent is not supposed to act until they're reasonably certain that the principal cannot. You can, however, draft a power of attorney and sign a power of attorney that gives the agent only the authority to act after a doctor has deemed you to be incapacitated. The problem with that is that it's difficult to get a doctor to sign off on that sort of recognition of incapacity because the doctor is afraid of liability. And you know, abutting against that is the fact that, you know, a lot of times in a situation where you need the power of attorney, you need it very quickly, and you just don't have that kind of time. So by having the power of attorney take effect immediately, but having a trusted agent who won't exercise that power of attorney until they're reasonably certain of your incapacity, you kind of find the happy middle ground there where they're acting, but only when you need them to act. Next slide, please. So this is interesting. Before, at the common law, a long time ago, a power of attorney would terminate when you became incapacitated. But the problem with that was, of course, that that's when you need it the most, is when you're incapacitated. So the modern law allows for what we call durability, and that means that the power of attorney persists through incapacity. Next slide, please. So power of attorney can be revoked at any time, and divorce revokes a power of attorney automatically. Next slide. Oh, and this is important, the power of attorney terminates automatically upon death. For a lot of people, their power of attorney is also the executor of their estate. Certainly not for everybody, but a lot of times it makes sense because that's the person who's been handling your financials in an incapacitated state in life, and so it makes sense for them to take over upon death. But certainly, people sometimes choose for different plans, and that's available. Next slide, please. Oh, and that's all I have. Thank you.
Thank you, Taylor. And then finally, we have Frank and Kat, who will talk about advanced medical directives.
Thank you, Professor. Thanks, Taylor. Good evening, everyone. And for the last portion of our presentation, Frank and I will be discussing advanced medical directives. Okay, so what are they? Advanced medical directives are legal documents that express an individual's healthcare wishes.
So at our clinic, we deal with mainly two types of advanced medical directives, the living will and the healthcare power of attorney. The living will are written instructions regarding a client's preferences for medical care if the client is unable to make these decisions. They address end-of-life circumstances, such as whether to receive or withhold life-sustaining treatments, feeding tubes, those sorts of things. And the healthcare power of attorney, also known as the medical power of attorney or durable healthcare power of attorney, lets the client, as the principal, give someone else, the agent, the power to make healthcare decisions on their behalf. Both of these documents have a standard form in PA, which we will show you later on in our slides. Next slide. So this is the standard form of the living will from the Allegheny County Bar Association. We also have more customizable form that we use at the clinic depending on the client's needs and wishes, but you can initial and sign next to each designation that you would want on the standard form. So the living will, what choices can a client make? They can choose whether they want aggressive medical care for an end-stage medical condition, whether they want food tube feeding, whether they want these instructions to actually be binding or just to guide their healthcare agent. And if they are only going to act as guidance, can they directly limit the power the agent has? And you can also choose whether you want to be an organ donor or to have your body donated to science, or what to do with your body after you pass away.
And next slide, please. Oh, yeah, got it. Sorry, could you please go back? I apologize. Okay, so this is our standard form for healthcare POA from the ACBA, and we also have, as Frank said, a more customizable form that we use depending on the client's needs and wishes. Next slide. Okay, so for healthcare POA, the principal, our client, can choose an agent and alternate agents, authorize healthcare personnel to share information about physical and mental health. A principal can also grant additional powers to their agents, such as authorize, withhold, or withdraw medical care and surgeries, hire and fire medical personnel to provide further care, carry out funeral and burial wishes, and in general, take any legal action necessary to ensure that the principal's wishes are carried out. Next slide, please.
So there are steps we advise our clients to take before they fill out these forms and during the process of making their decisions here. First is to talk to their healthcare providers so that their healthcare providers have a better understanding of the patient's wishes And so the patients have a better understanding of where their health is at and what their current goals would be. So then after that is deciding what their healthcare goals are. After they decide what their healthcare goals are and maybe what kind of treatment they would like to receive, talk to their healthcare providers and to make sure that they're willing to follow the guidance that they would give. Have a discussion with your potential agents and any alternate agents you would name to give them guidance to make sure the agents understand the documents, understand the principal's wishes, and that they're willing to follow their wishes. Then to discuss the advanced healthcare directives with relatives and close friends to make sure they all know who will be making these decisions if it's not one of them, and possibly what the decisions would be. Finally, ensure that the advanced healthcare directives are given to their primary care providers and that they are on file with their hospital and their doctors. So that way, if something happens and they are incapacitated, the doctors will know who to contact. And with that, ensure that the hospital has updated contact info for their agents so that there is no confusion and you are able to get a hold of them when a decision does need to be made.
Okay, so why is it important to have an advanced healthcare directives? I'm sure as doctors, many of you have been in a situation where an unconscious patient was brought in by a relative who had no idea whether their loved one has or had an advanced healthcare directive. Or the patient may have been brought in unconscious from a nursing home or an assisted living facility that didn't have that patient documents on file. This is the reason why we tell clients to make sure that they let their relatives, friends, healthcare agents, PCPs know about their healthcare wishes and why it's so important for clients to have this information on file with the hospital. And of course, also why assisted living facilities and nursing homes should also have these documents on file. And that's all we have. Thank you.
Thank you. I'm going to stop my share and we're willing to take any questions that anybody might have. I'll turn it back to Dr. Wilds. And again, thank you for allowing us to join you this evening.
Well, thank you so much, panel, for that wonderful presentation. 2 questions, and then I have a question of my own I'd like to ask. But one of the questions in the chat, if you have a home that is not paid for, can you leave it to someone in your will?
Absolutely. And I will ask the 2 students who talked about wills to clarify.
Yeah, so you can leave your house in your will. It'll just be subject to the mortgage if there is a mortgage on the property still. So you can either have, in some ways, you can have the estate satisfy that mortgage, but typically with clients that are lower income, if you don't want the person to inherit that mortgage, typically they would have the house set for sale and they would get the proceeds that are left over after the mortgage is satisfied.
Okay. All right. Thank you for that answer. The next question is, please explain a trust.
My caveat is that in the wills clinic, we do not prepare trusts outside of special needs trusts or preparation for minors who might be receiving funds. But trusts essentially allow you to take money out of your estate and place it in a, what should I call it? It's a system of managing your money such that you don't have direct control of it. It is held by the trust, it is titled by the trust, and it's used for a variety of reasons, whether it's being kept to save money for future generations, whether it's to allocate assets so that you are eligible for certain government benefits like Medicare, Medicaid. There are various reasons to have a trust. Again, we do not prepare trusts in the clinic, but we are happy to connect you with the Bar Association who can direct you to trust planning attorneys.
Okay, thank you. I don't see any additional questions in the chat. Those were the 2 that I did see.
I saw one, I don't know where it went, but somebody asked, I saw they asked about, can you have multiple agents on a power of attorney? I saw that.
I must have missed that one. Thank you.
I got missed, but I'll answer that since I did. I presented on the power of attorney, and the answer is yes, you can. And actually, it's a good idea to, especially if those agents are successive agents. For instance, you appoint an agent as your power of attorney, but if they can't serve, then you appoint a secondary one. And that's a really good idea, in case the first person is unable to serve as your power of attorney. You also can appoint simultaneous agents, but that's less of a good idea because you get into a situation where the two agents might disagree about what should happen. And then you wind up in a situation where nothing's happening because they can't come to a decision together.
Okay, all right, thank you. Another question, this may be a comment that says, these services are so necessary for low-income persons. Does this mean that there is not a parallel service for those who are not eligible for your services?
If you are not eligible for our services, we generally refer you to the Bar Association, and you can hire an attorney, of whom there are many qualified Duquesne law graduates providing these estate planning services to the community. But yes, we would just refer you to the Bar Association to hire an attorney to get this done.
Okay. Next question, if you have a trust, do you need a will?
I'll answer that. And the answer is everybody needs a will. Even if you put your items in trust, you may still have the stuff in your house that you want to allocate in a will. And again, the provisions for minors, for special needs individuals, you have to put in a will. So yes, you would need a will regardless of whether you have trusts, just for the items that don't get or stored or taken over by the trust, for any extraneous items.
Okay. Next question. If you get a template for a will online, should you get it notarized?
And Melanie?
It's not completely necessary, but I would say yes, that you should get it notarized or have witnesses that are not related to you to sign it. But I would definitely recommend having an attorney do it instead of trying to do it yourself, because you may leave out a provision that could be necessary. You may leave out one of the sections that Anna and I discussed. The ones online aren't catch-all. They don't include every single thing, and some of them are kind of state specific. So Pennsylvania does it a certain way that other states wouldn't necessarily do it. So Pennsylvania doesn't really require notarization, but just to cover all your bases, it's good to do that.
Okay, thank you. Is the attorney handling the estate paid a flat fee?
It depends on what their fee arrangement is. I think different attorneys do it differently. It depends on your personal arrangement with your attorney. However, they are, compensated often by the amount of work that they do and how many hours it might take.
Okay. Next question. What are the ways to avoid probate and inheritance taxes?
So inheritance taxes in Pennsylvania, and this is something we didn't talk about, are not that terrible. There's a lot of people trying to avoid probate and avoid inheritance taxes, but for a spouse, it's the rate is 0%. Spouses don't pay inheritance tax. For your direct children, it's 4.5%. So the amount of money you're going to spend trying to get around paying your probate taxes or inheritance taxes and paying an attorney, you'd have to make that determination about whether it's worth it. There are ways to do it. That's through trust planning and moving assets around to different places. There are ways to do it. I would again recommend that you consult with an attorney and determine whether that's the right decision for you, depending on who's inheriting your property.
Okay. All right. I don't see any additional questions in the chat. I hope I didn't miss anything. Is there anything else, panel, that you would like to say before we have closing remarks and we depart for the evening?
I wanted to make one mention of guardianships, which is something that everyone has alluded to. Without any of these documents in place, particularly the healthcare and financial powers of attorney, any individual runs the risk of having guardianship proceedings where, a court comes in and it's very intrusive, digging into the very personal details of your life in a court proceeding. And all of that can be avoided by simply stating your wishes in advance. So if nothing else, just to be able to avoid having family disagreement or lack of information about your wishes that might lead into the guardianship process for any caregiver or for any of us who will need to be cared for in the future. Getting these documents in place now while you have the capacity is critical, because there is a time for everyone where it becomes too late to do them. And at that point, the court system may take over.
Okay. I do see another question in the chat. Should you share your will with all family members?
If you'd like to. Depends on your relationship with your family. Usually our clients store them in a safe place in their house where someone has access to the key or access to the lockbox code. It depends really on your relationship with your family. If you feel comfortable sharing it with everybody, and you're not going to make changes, because then you'll have several copies of the will in various versions floating around. That's a decision that you're free to make.
All right. Okay, I don't see any additional questions in the chat. So I'd like to, oh, here's another one. If you have listed beneficiaries on your retirement, IRA, et cetera, do you still need a will?
Does a student want to answer that question?
The answer is yes.
The answer is
So the only property then that's passing by beneficiary is the retirement and the IRA, but you still have a lot of personal property, maybe real estate, whatever you may have, it that needs to be in a will. Yes. I mean, if you have any interest in where it goes, then yes.
There's also the danger that the beneficiaries on your accounts may not be able, may not want to, or may not be alive to take the proceeds of your retirement account or your life insurance policy, in which case it would default to your estate. And if you don't have a will, then the laws of intestacy will take over. So it's best to have a backup, to just state in your will what it is that you want to happen in the event that there are no beneficiaries.
Okay.
We mentioned intestacy laws a little bit, but I don't think anyone really talked about what they are. So some people have, like, some clients have come up to us and said, well, we don't have a lot of money, so I don't really need a will. But if they have a house and a spouse and their parents are still alive, I mean, half their interest in their house could go to their spouse and the other half could go to their parents. And so you don't really want part of your house to be owned by your parents and the rest of it to be owned by your spouse. If you pass away, that could have a big conflict. And usually for the clients that we've been helping, that is their biggest asset, is their home. And so that would just not be a good thing to pass that way. So for it going through a will is so much more helpful.
Okay. And one final question in the chat. Can you make amendments to your will without redrafting it?
The answer to that is yes, Dr. Wilds, you can. Again, I would consult with an attorney to determine why it is that you are making the changes that you're making, but you can add a codicil. It's called a codicil. It's just sort of like an amendment to your will, a little document that attaches to your will. But if you're getting lengthy and complicated, you're probably better off doing it all over again, provided you have capacity to do so.
Okay. Thank you so much, panel. Thank you, Gateway Medical Society, Alpha Kappa Alpha Sorority Incorporated, Alpha Omega Chapter, and generous sponsors. And Dr. Orsatti and your students, a special thank you, and to the Duquesne Law School for presenting on this very important subject. I think we all need to know at some point we may be caregivers, we may need this information ourselves, and we're grateful that it is available. So again, thank you very much, and everyone have a great evening, and thank you for joining us.
Thank you so much.